Hello and welcome. I'm Valerie Paley, Senior Vice President and Sue Ann Weinberg Director of the Patricia D. Klingenstein Library at the New York Historical Society. Before we begin, I would like to thank Louise Mirror, our President and CEO, Agnes Sue Tang, Chair of the Board of Trustees, and Pam Schaffler, our Chair Emerita, as well as all of our trustees, Joyce B. Cohen, Diane Max, and the late Adam Max, and the Andrew W. Mellon Foundation, along with our Chairman's Council, our members, and our many other generous donors. None of the work of New York Historical would be possible without your continued and committed support. I am privileged to be recognized as the founding director of our Center for Women's History, the first such center of its kind within the walls of a major museum in the United States. In only a few short years, we've been able to accomplish so much in terms of scholarship, education, programs, collecting, and not least of all, exhibitions, all of which foreground women's critical role in American history. Tonight's important program is emblematic of that mission. The end of Roe, breaking down the Supreme Court's final decision, will last 1 hour with no Q&A. And now I am honored to introduce today's speakers. Michele Goodwin holds the Chancellor's Professorship at the University of California, Irvine, and is the founder and director of the Center for Biotechnology and Global Health Policy and its internationally praised Reproductive Justice Initiative. An acclaimed author, constitutional law scholar, and bioethicist, she is the author of several highly acclaimed books, including Policing the Womb, which chronicles how women's reproduction has become the political scapegoat in Congress and legislatures across the US. Mary Ziegler is a law professor at the University of California, Davis. She's the author of 5 books on the history of struggles over reproduction, including Dollars for Life, the Anti-Abortion Movement, and The Fall of the Republican Establishment, which Yale University Press published last month. Melissa Murray is the Frederick I. and Grace Stokes Professor of Law at NYU School of Law, where she teaches constitutional law, family law, criminal law, and reproductive rights and justice. Apart from her writing, which has appeared in a wide range of legal and lay publications, Murray serves as legal analyst for MSNBC and is a co-host of Strict Scrutiny, a podcast about the Supreme Court and the legal culture that surrounds it. Our moderator, Irin Carmon, is a senior correspondent at New York Magazine and co-author of Notorious RBG, The Life and Times of Ruth Bader Ginsburg, which spent 3 months on the Times bestseller list. She has been a national reporter at MSNBC and NBC News, as well as a staff writer at Salon.com and Jezebel.com, covering gender, reproductive rights, and the law. As a contributing writer to the Washington Post's Outlook section, she won a 2018 Mirror Award from the Newhouse School at Syracuse University for her work breaking the story of the sexual harassment allegations against Charlie Rose. She speaks frequently across the country on women's leadership and rights. New York Historical is honored to welcome this distinguished panel.
Thank you so much, Valerie, and thank you to these distinguished panelists. If at a moment of enormous consequence in American history and law, I cannot think of a more distinguished lineup of legal scholars and people deeply steeped in reproductive justice, rights, health, and history than these individuals before me. So thank you so much for joining us tonight. I want to start out, I'm thinking that we'll basically break down the conversation into thirds. First, let's talk about Dobbs, what it did, what it said, how it was written, the extraordinary way in which it appeared in the form of a leak first. Then I'd like to talk about your views on how we got here, which I know you have all made impassioned and original arguments, helping us understand the historical antecedents of this moment. And finally, of course, would like to leave our viewers help them understand how we move forward, how the law moves forward, and what you expect will happen. Because in just the 10 days since this decision came down, there has been a dizzying number of political and legal developments that I'm sure even those of us who are steeped in this full time are struggling to keep up with and understand the implications of. So let's start out with Dobbs. I'm just going to very briefly read the most consequential part of it. Justice Samuel Alito, in a majority opinion that looked basically identical to the leak that appeared 6 weeks before, said, we hold Roe and Casey must be overruled. The Constitution makes no reference to abortion, and no such right is implicitly protected by any constitutional provision, including the one on which the defenders of Roe and Casey now chiefly rely, the Due Process Clause of the 14th Amendment. And he says that this opinion in Dobbs versus Jackson Women's Health will, quote, return the issue of abortion to the people's elected representatives. Unlike in the case of the leak, there were other opinions that we had an opportunity to read the moment this came down. Of course, there were 3 concurring opinions from conservative justices. And there was, of course, a united dissent from 3 Democratic appointees who said that the result of today's decision is certain: the curtailment of women's rights and of their status as free and equal citizens. Now, those of us who've been following this for a long time know that there's a lot of talking around these issues that has happened for a long time. Rarely do we see the justices squarely put their cards on the table, confront exactly what is at stake, whether it is the majority opinion, making it clear that they open the door to a nationwide abortion ban and to ban abortion in the short term in half the states, and the Democratic dissenters really, in my view, pulling no punches. So that's just to set the stage. Melissa, let's start with you. Tell me, we had some time to prepare, but you are sitting there reading the final opinion and all of the additional concurrences and the dissent. What jumped out at you about how Dobbs came down, how Roe, after almost 50 years, was finally overturned?
Well, the first thing that struck me, and let me back up and say thank you all for joining us today. Thanks so much to the New York Historical Society for convening this, and to my fellow co-panelists for being here as well. The first thing that struck me when I read the final opinion was how similar it was to the leaked draft opinion that appeared in May. And it's typically the case at the Supreme Court that opinions will go through some kind of iterative process. Ruth Bader Ginsburg famously noted that her interactions with her colleague on the other side, Justice Scalia, often prompted her to revise her thinking about a particular issue, to sharpen her analysis, and indeed led to a stronger opinion. There was no indication that that kind of iterative process took place here, even though this opinion was out in the world for historians and other scholars to attack. And there was quite a bit of crowdsourcing about what the infirmities around Justice Alito's analysis in the draft opinion were. But you didn't really see that in the final opinion. There were some nods to the dissenting opinions and the concurrences, but for the most part, it was largely unchanged. So, this was definitely an opinion where Justice Alito looked at it and was like, "You're perfect, you're beautiful, never change." and
what do you make of that? What's the implication of that?
Well, I mean, I think to the extent there was a lot of discussion about why the leak occurred and whether or not it was meant to sort of put pressure on someone who may have been wobbling or on the fence, it was very clear that, at least to some, that one of the repercussions of the leak was to really firm up support for the draft opinion as written. There really was no give there in the end. And so the opinion does what we saw it do in the draft opinion. It makes clear that Roe versus Wade and Planned Parenthood versus Casey, the 2 principal opinions outlining the right to an abortion, are, in the words of the majority, a constitutional apostasy because they are unmoored from constitutional texts and are not deeply rooted in the traditions and history of this country. And again, leaving aside the question of the law at issue here, Mississippi's 15-week ban on abortion, that could have been upheld, as the Chief Justice notes in a concurrence, without overruling Roe versus Wade. The majority does not take that view at all. And so this is an opinion that is sort of apocalyptic in its scope. It lays waste to almost 50 years worth of precedent. It upholds this Mississippi law. I think it opens a number of questions as to what range of restrictions on abortion we are going to see going forward. We've already seen the landscape for reproductive rights change drastically. And we haven't even gotten to the concurring opinion. So I've alluded to the Chief Justice who tried to broker compromise, as it were, not truly a compromise, because upholding the Mississippi law even if you don't overrule Roe versus Wade, essentially eviscerates the principles behind Roe versus Wade. But he would have gone slowly. And, I think that is the distinction between the Chief Justice and the majority here. They're definitely on the same page, and they're definitely on the same page about where we should wind up. They just are on different pages as to the timing of how we get there. And then there was Justice Kavanaugh's concurrence, which suggested that this was simply restoring to the states the question of whether abortion could be permitted within each state's jurisdiction. So he said this would be returned to the states for democratic deliberation. What he doesn't say is that, this court has been really pivotal in dismantling some of the framework and infrastructure that allows democratic deliberation to happen so that all persons in a democracy who are eligible to participate may do so. He also noted that in leaving this open to democratic deliberation, this would be decided by the people and Congress, right? So the people through their state legislatures and Congress. And I think that very much gestures to the prospect of what may happen in 2 or 4 years, where we may see a change in the balance of power at both the congressional level and in the presidency. And perhaps we no longer see this being a state by state deliberation, but rather a federal ban on abortion entirely. And his concurrence definitely does contemplate that. But most of the attention, I think, outside of the majority opinion was reserved for Justice Thomas, who penned a quite startling concurrence in which he sort of said the quiet part out loud. And I actually was very happy that he wrote this concurrence, because after reading the draft opinion, I said that there was no way to limit the logic and the analysis of that draft opinion to just the abortion right, and that other rights would be implicated as well. Sorry, I have a dog who's very exercised about the changing landscape of reproductive rights. But Justice Thomas made very clear that he too saw the implications of the majority's decision-making on these other rights. And he essentially invited his colleagues to, in the future, take up the entire line of substantive due process cases, from Griswold versus Connecticut, which secures a right to contraception, all the way to Obergefell versus Hodges, which legalizes same-sex marriage. And to be sure, he did not get any other votes for that position. But I think what that concurrence does is invite challenges. So I think we will see in the very near future new cases being filed that will challenge the right to contraception, challenge the right to same-sex intimacy, and challenge the right to same-sex marriage.
It's interesting, because I think what you're saying is that, Alito found his opinion to be perfect, but Alito, and to a greater extent, the concurrences by Roberts and Kavanaugh are, to some extent, a little bit dishonest about the long-term game here. And I think you're too polite to say so, but in the aftermath of the leak, many people were saying, including distinguished law professors, that it was hysterical to worry about the slippery slope of undermining these readings of the Constitution, including the 14th Amendment. And so to then have Thomas say, no, we actually do mean that, it's perversely validating, perhaps, because, if you look at all of Kavanaugh's opinion in particular, it's sort of like, hey, ladies, I'm still a nice guy. This isn't such a big deal. We'll just return it to the people. But also a national ban, the states, but also so in some ways there is something very clarifying about Thomas. And I wonder whether he didn't get any other votes because he's one of the oldest members. Maybe he is the oldest member now with Breyer's retirement. The others have plenty of time to get there, don't they? There's no reason for them to lay all their cards on the table. Mary, as a historian, in addition to being a legal analyst of the right, I wonder what you make of these different approaches to ultimately the same outcome. Even Roberts' opinion, although he wanted to go slow, was not a dissent in part, right? It was he didn't put his name on the majority opinion, but he concurred in the judgment. What do you make of these different ways that the conservative justices got to this outcome? And did it shock you? Because I know you have a very clear-eyed view of the conservative movement, but I also know that at one point you and I were talking after Dobbs was taken, but before our argument, and you thought maybe they wouldn't go all the way this time. Mm-hmm. You thought they wanted to go there, but you thought strategically they would not fully overturn Roe v. Wade. I don't mean to call you out. I'm just curious.
No, I was wrong.
How did it get here this fast? Tell us more about what you make of how they got here in the end, in terms of reflecting goals of these broader based movements on the right.
Yeah, I mean, the different opinions that the conservative justices have kind of broadly track different strategies you've seen develop in the anti-abortion movement over the past couple decades, right? So if you remember, there have been lots of laws with different gestational limits, right? There are 20-week bans, there are 6-week bans, et cetera, right? All of those were designed to kind of produce as a step toward the reversal of Roe, something like Chief Justice John Roberts' concurrence, right? The idea being that if viability went, there would be very little supporting the remainder of an abortion right. So a lot of the arguments that you see Chief Justice Roberts make were made by anti-abortion lawyers, were made by anti-abortion advocates, were part of a lot of the gestational limit strategies that you saw really beginning, I think, in around 2010, and to some extent even before that. Some of the arguments about viability as the kind of Achilles heel of reproductive rights you can find being made all the way back to the 1980s. You see in the majority, it's just replete, I can't tell you, with anti-abortion talking points. The language, the comparison, the idea that Roe is egregiously wrong, the repeat comparisons of Roe and Plessy versus Ferguson, which was the decision upholding separate but equal. The idea that Roe should be overturned in part because it failed to settle the abortion conflict, which is not something we historically have cared about when we think about whether to preserve precedent or discard it. That is an argument directly from Americans United for Life. Again, I think, ironically, maybe not ironically, the majority kind of tracks what I would consider to be kind of the arguments of the anti-abortion establishment on this point, which may be no surprise. And Justice Thomas's claims, I think the fact that Justice Thomas was alone is not really that revealing either, because of course, historically, Thomas would often write for himself and say that Roe v. Wade should be overturned. And we know now, of course, that there were many more votes for that proposition than we would have assumed at the time. So we know only what people are willing to say publicly at this point. I think how this happened so quickly, I think speaks more to how different this court is. So I think many of us, when we saw the court's composition change during the Trump administration, expected that Roe v. Wade would probably get overturned at some point. But I think I was of the opinion publicly that it would behoove the court to move more slowly, to kind of save face, right? To do what I think John Roberts was trying to do here, which was to sort of confuse people and say, viability isn't the same as abortion rights. And we can conserve something like the core of abortion rights. And look, we're going to perform intellectual seriousness, and we're going to take a long time to decide this. And we're going to do the things that make us look like a court and not like partisans. And quite clearly, the people who are on the court now are not interested in, either they don't believe that kind of performance actually works in terms of convincing people that the court is something other than a partisan entity. I think if you're reading Alito's opinion and you're reading into the fact that so little about it changed, I think it's better to say they don't care if the court is coming across as a partisan entity. There's a very revealing part of the draft, both the leaked draft and the majority, where essentially the court is discussing legitimacy, right? The potential damage to its legitimacy in response to a passage from Planned Parenthood versus Casey. And Alito wrote in the draft and writes here, essentially, if people don't like this, if this is not in accord with popular opinion, one, we can't predict what effect that will have on the court. And even if we could, quite frankly, we don't care, right? This is a court essentially saying, we are unmoored from what you think. We are unmoored from traditional constraints on the court. We're going to do whatever we think is right. We're going to discard precedent whenever we feel like we need to. And, if you don't like it, tough luck. That's very much kind of the register that the opinion sounded in. And so I think the fact that it happened quick, the fact that it happened at all is a product of this much longer history to undo Roe, a much longer history that the anti-abortion movement, worked in through changing the GOP and changing campaign finance and doing all of these other things to change how our democracy works, changing access to the vote. But the point about, why how the foot got put on the accelerator is I think that this is a very different court, not just insofar, it's not that it's a conservative court. We've had those before. It's this kind of, I think, disregard for how this is coming across and the potential cost to the court as an institution, and how it's traditionally functioned in our democracy.
So even in oral argument, before there was a draft that we know of, you had Justice Sotomayor saying, can this institution survive the stench? And Breyer as well, raising the concern that because Trump has appointed 3 justices, probably most crucially Anthony Kennedy and Ruth Bader Ginsburg being off the court, that suddenly this outcome is going to happen. And of course, in the dissent, They say the court reverses course today for one reason and one reason only, because the composition of this court has changed. Michele, I wonder if I could ask you to reflect a little bit on the joint dissent, because we haven't talked about it. And to my mind, it is really an extraordinary document that goes in places that, even some of the most famous dissents, I think, were too polite to go. I wonder what your reaction was to how it was constructed and its arguments and its role in speaking to the public.
Well, I think to your point, Irin, and again, I want to thank all gathered here and the New York Historical Society for centering this event, not the first of which we've been together, Irin. But I think that what the dissent did was to make clear that we are in incredibly dangerous times for the rule of law. And what is so stunning about the substance of the decision itself is really articulated in the dissent itself, which is that this is a Supreme Court that has lost its anchoring and its mooring. This is a Supreme Court that has turned its back on stare decisis in this way. This is a Supreme Court that has now overturned what was a fundamental right, something that the Supreme Court has never done before. And before now, it's important to note that there were various justices on the court that were ringing that bell who are in the dissent, most notably Justices Sotomayor and Justice Elena Kagan. Some would say that Justice Breyer has been more mild on the point. I think that is probably true. But Justice Kagan has previously said that this was a Supreme Court, the majority that we saw in this case, but even before, I'm thinking of Nifla v. Becerra, that there is a weaponization of the First Amendment that was taking place. Justice Sotomayor has said previously across an arc of cases, but even in this particular term, in the matters that came before the court involving the Texas law, SB 8, that this was a court that was engaging quite dangerously in a way in which the American people would deserve to lose confidence in this court. And by what we have in this decision in Dobbs, they are absolutely right. To the point that was made by Professor Murray, what's notable is that we have a final opinion that's not very different at all from the draft, which says a lot about what could have been removed, what could have been tweaked. There were significant omissions and errors in this opinion itself. None of that was corrected for. Instead, what we saw was some debate around what the dissent offered, but otherwise, it is a very bold statement that has been made by this ultra-conservative majority of the court that has not only overturned Roe v. Wade, but in a number of ways has really cast the court into managing affairs as if it were in the 1700s or early 1800s, rather than in 2022 addressing matters of reproductive health rights and justice.
Right, and to that point, that the majority opinion was not responsive to this unusual public debate that was able to take place before it was finalized. I felt that the dissent was extremely responsive to many of the arguments. Many of their citations were pieces of reporting that came out after the leak. A lot of we talked about this sort of high-level legal gaslighting. They were directly responsive to the concerns, not just to Thomas, but also sort of implicitly speaking about what about birth control? What about miscarriage management? What about the criminalization of women and pregnant individuals? All of these things that the majority says either doesn't mention, doesn't acknowledge, or says don't worry, they actually, in the dissent, raise and say these are legitimate concerns as the state takes away the power from the individual pregnant woman or person and puts it in the state's hands as the court does this. And so I thought that was really interesting, that it seemed like the dissent actually was reading and listening to all the conversations, whereas there were these sort of blinders on for the majority where it's like, we're just going to do it.
The two very dramatically different approaches that was taken by the court when you look at, on one hand, with the majority refusing to pay attention to the high rates, the alarming rates, outlandish rates of maternal mortality and morbidity in this country, to pay attention only around Roe v. Wade and very limited in that way. And then you have a dissent that says we recognize the data, the very real data that's been reported in prior Supreme Court cases, such as in 2016 in Whole Women's Health v. Hellerstedt. And then also the data that we have that is, as you say, current right up to the moment. But I think it also reflects something else, which is that the American public is really losing faith in the Supreme Court itself. And I think that by the dissent, with paying attention to the criminalization matters, paying attention to the fact that there's some things that we just simply don't know, but that legislators are claiming that they may want to do, such as to track people across state lines, interfere with interstate travel, civilly punish, all of these things from maternal mortality and morbidity to the criminal matters and civil matters. These were issues that were addressed in the dissent. And it was as if with the majority, hear no evil, see no evil, we'll pay no attention and put our fingers in our ears and pretend the rest of America really doesn't exist outside of their own island and the island of legislators that have been very keenly invested in an anti-abortion movement.
Michele, I want to stay with you because I want to talk about how we got here. And I think that in particular, your most recent book has been really prophetic, Policing the Womb. You talk about both criminal and civil liability for pregnancy outcomes. And you talk about things like travel over interstate lines, which, you know, frankly, was talked about a little bit before the opinion, but we're now seeing really the sort of bubble to the surface as people, as legislators, really want to track and surveil all pregnancies to track down the outcomes and make sure that they're compliant with what they think is the right outcome. So talk to me about how we got here. Where could we have seen, and I know that everyone who is on this panel and probably a lot of the people who are listening here were not under many illusions, but for the broader American public, where were the warning signs and what are some of the ways in which we could have seen this coming if we knew where to look?
So thank you so much for that question, Irin. I've been calling this a period of a new Jane Crow. And to understand the old Jane Crow, we could look at the works of Pauli Murray nearly a century ago, making very clear that we should be intersectional in our thinking with regard to this nation's practices and policies as they relate to women of color. So let's be clear that in the 1980s and 90s, there was dramatic surveillance that hasn't really eased up, targeting Black women during pregnancy, targeting Latinas during their pregnancies, such that when they wanted to be pregnant and carry pregnancies to term, they were policed in such ways that would lead to criminal punishments, that could lead also to civil punishments as well, including their children being removed from the home. So when we think about the kind of post-mortem of this, what I'm talking about are matters involving, in the 1980s and 90s, this kind of horrific storm of the stigmatization and stereotype of the welfare queen, right alongside the American war on drugs, the so-called war on drugs, mass criminalization, and basically that serving as a backdrop for targeting Black women during their pregnancies. Black women were 10 times more likely than their white counterparts to be reported to police or reported to Child Protective Services for having stated to a medical provider that they used an illicit drug or something of that sort during pregnancy. We saw prosecutors using laws that were not applicable to these women, but doing so to get coercive plea deals, such as using child abuse statutes against pregnant women, such as wielding RICO laws and drug laws, such as delivering drugs to a minor in order to prosecute Black women who were pregnant. We saw Black women taking plea deals in cases of miscarriage. We saw kids as young as 16 years old, Renee Gibbs in Mississippi, being targeted with depraved heart murder in Mississippi for having a stillbirth. We saw cases like Regina McKnight, 23-year-old Black woman charged with manslaughter for, again, having a stillbirth. And for the most part, these women were the euphemistic canaries in the coal mine. And really, I think a point that's important here is that we see the materialization of a conservative movement that's been more of a marathon than a sprint. But at the same time, it's worth noting the ways in which reproductive rights organizations really dropped the ball rather than seeing these women as being part of what should have been part of their community too, and defending their interest. That ball was dropped. And one way of thinking about this, Irin, was that really what was being established at that time was a kind of personhood in the fetus, which now materializes in Justice Alito's opinion being riddled with the term unborn child, something that didn't exist in law before, something that is not articulated in our Constitution, but has been something that's been in practice now by anti-abortion forces and law enforcement for the last 30 years or so.
Right. I mean, it's a blueprint for fetal personhood, and I think it's also, as you mentioned, a blueprint for the mechanisms by which someone's pregnancy becomes a matter of criminal law, right? I mean, given how much we haven't mentioned this yet, but the technological change, the ability in many cases to self-manage an abortion, where you don't need to find a doctor necessarily if your pregnancy is not too far along. You can get pills by mail, even if it's illegal in your state. But this kind of pattern of surveillance and doctors calling the cops on you when you're seeking pregnancy-related care, there's a blueprint for that already. If everybody says, how will they know? Well, how did they know with Rennie Gibbs or Regina McKnight?
Exactly.
And of course, we know, obviously, Black women being surveilled more often, but I'm sure that disproportionate attention is going to continue. But now that the scope has opened up even wider for a full recognition of fetal personhood from this opinion, we can expect it to be even more ubiquitous. Melissa, I'm wondering, you've written about the way that race is deployed by Clarence Thomas. There's some implicit Amy Coney Barrett stuff, even though she did not write separately with respect to safe haven laws. I'm wondering what you make of the sort of let's call them the grace notes of the opinion that tell us a little bit about a history that's being built here, right? How did we get to the point where Clarence Thomas is influencing or is writing the way that he is about race and abortion? Just to start with, give us some historical perspective and tell everyone what I'm talking about.
So this is such a big and important question, Irin. I think what is sort of interesting to note is that this conservative Supreme Court has been deploying racialized language, sort of tropes around racial justice around a number of issues, not simply abortion. For example, in footnote 41 of the Dobbs opinion, Justice Alito includes a very curious footnote where he talks about a number of amicus briefs that note the quote unquote connection between abortion and the eugenics movement, and specifically the connection that is identified comes from an earlier concurrence that Justice Thomas solely authored back in 2019, where he argued that the high rates of abortion among African-American women is the modern day residue of the campaign on the part of Margaret Sanger and Planned Parenthood to work with the eugenics movement to cite family planning clinics in African-American neighborhoods. And this is a very selective history. It is not at all nuanced. Like, it is true that Margaret Sanger did work with eugenicists, but not simply because she was advancing abortion. She was very much interested in advancing family planning for purposes of population control. She didn't use the racialized language that the eugenicist used, and instead she sort of riffed on eugenics because at the time it was understood as a science, and she was trying to invoke that kind of imprimatur of science and legitimacy for her movement at a time when she had failed to garner the support of mainstream feminists because, in addition to arguing for voluntary motherhood, she was also arguing for sexual pleasure, which the first wave feminists were not really into. So, I mean, there's a lot you could say there about divisions among the left around different issues, things that still resonate today in a lot of different ways. But this narrative about abortion as eugenics is something that Justice Thomas has really husbanded, and it has really flourished in the lower federal courts. So last year, the Sixth Circuit announced a decision upholding an Ohio reasoning. I'm sorry, we're out in California. Our dog is a New York dog, and there are just too many things happening in the wilderness out here for him.
He's very upset about Clarence Thomas's concurrence.
Well, he's also, I think, exercised about Justice Thomas's concurrence, but the concurrence basically makes this argument and links abortion and eugenics, and it's really flourished in the lower federal courts. The Sixth Circuit, both the majority opinion and several of the concurrences referenced it in the opinion in preterm Cleveland Clinic versus Himes, which was decided last April. So it's taken root there in the context of abortion. It's in this Dobbs opinion, which is actually quite curious because it's entirely gratuitous, a grace note, as you say. It's not necessary to overrule Roe by linking abortion to eugenics. So I think one of the roles that it serves here is that it actually links this prospect of eugenic deracination to contraception, which leaves open the sort of question of what comes after this opinion. So I think this is a very clear way to discredit the right to contraception by linking it to racial injustice, and more to say about that. But it's not the only place this court has done this. So, for example, in the Dobbs case, the Bruin case, the New York guns case decided just the day before Dobbs, the court also, in an opinion written by Justice Thomas, invoked a lot of racialized language, essentially saying that the history of racialized violence that occurred against newly freed African Americans in the period following Reconstruction was directly linked to the state's refusal to enforce Second Amendment rights for newly freed African Americans. And so, as that logic goes, the antidote to racism and racial violence is actually to empower African Americans to have arms, to bear arms. And so, Justice Alito, in his concurrence, runs with this, talks about racialized violence against certain communities, notes that there are certain racial communities that filed amicus briefs in favor of dismantling New York's concealed carry scheme, including the Asian American community. So there's this really interesting movement afoot at the court to sort of be woke about certain pet issues, which is really, I think, noteworthy given that the rest of mainstream conservatism is actually not interested in quote unquote being woke on other issues. So, this is the same conservative legal movement that has decried critical race theory, that has argued that any discussion of race at the elementary school level or even the middle or high school levels is tantamount to indoctrination, and they ban books dealing with racialized content. There's a movement afoot, I think, in Texas to rebrand slavery as involuntary labor or something of that nature. So, it is curious that where it is convenient, where it is useful, we see the court and indeed larger aspects of the conservative legal movement doing this. And, they're responding, I think, to a broader discourse in which, we as a majority of society actually are interested in questions of racial justice. We've seen this with George Floyd. We've seen this in the reproductive justice movement that sought to make clear that reproductive rights don't just end with certain populations, but we have to think about them in the context of race, in the context of disability and intersectionality, and really prompted, I think, the mainstream reproductive rights movement to expand their agendas to include a broader constituency. I think this is the conservative movement really responding to the success of those progressive movements by co-opting some of the language of race and deploying it for their own purposes. So, not to be too cynical about it, it is a bit like playing the race card in this case, only in areas where, it actually helps to sow division among progressive coalitions. And also, I think, helps to sort of muddy the waters about what are quote unquote progressive causes and what are conservative causes.
I actually feel that you were being very charitable in that read. To me, it reminds me of, for example, Trump deploying the phrase super predators against Hillary Clinton, or bringing the women who accused Bill Clinton of sexual assault to a debate. The the not nice word for it is trolling. But as you say, there are vulnerabilities that they can exploit. There's some of the vulnerabilities that Michele mentioned. If there weren't these actual divisions and blind spots, it would be harder for them to try to sow that division, even if they do so in a dishonest or cynical way. Mary, I wonder, some of what we've been talking about up until now has been, we focused mostly on the conservative movement and its enormous success here. I wonder if you could take a comparative perspective in terms of the movement that supports abortion rights and where you think the divergence happened. Is it just, that they focused on the Supreme Court more? Is it just that they got lucky with retirements, strategic retirements and deaths? Did they win the argument? Did the pro-choice movement take its eye off the ball? This is one of many millions of theories that I've heard circulated over time. And I'm just wondering if you could help us understand from a movement perspective, not only how the conservatives won, but how those who support abortion rights lost, at least for now.
Yeah, I mean, I think there were definitely mistakes made by progressives. Michele alluded to some of them, and these are quite clear in the archives. You see, I think, a kind of almost deliberate lack of concern for issues affecting people of color. This is really, I think, it's kind of heartbreaking when you read archival material about the deprioritization of the Hyde Amendment, where you'll see someone will come up from one of the kind of larger, richer pro-choice groups and say, you know what, this is kind of bad that people of color are being affected by the Hyde Amendment. We should really care about access. And then someone will write an email or a memo back saying, yeah, but you know what, donors don't care about that. And they don't really care about these people of color. And neither do these politicians in the Senate. And we kind of need them too. So we'll like worry about that later. And this happens literally like over and over and over again in the 80s and 90s. And so you have a disconnect between the communities that are the most affected by what are kind of increasing, accelerating waves of abortion restrictions, and the message and the focus of the movement that's fighting those restrictions. And so there's almost, I think, kind of a professionalization of the pro-choice movement. You see the pro-choice movement increasingly focusing on things like focus groups, polls, and a kind of withering away to some degree of the grassroots side of the movement that would have been in a better position to fight some of what you see going on the right. I think that was accompanied by a kind of weirdly kind of contradictory attitude toward the courts, where you see as early as the 80s, pro-choice groups ostensibly saying, we can't rely on the courts have conservative majorities, we need to focus on politics. And that's, in fact, our focus on politics is the reason we can't think too much about people of color, because the average median white male independent voter doesn't care about the Hyde Amendment or contraception or sterilization abuse or criminalization of pregnant people. They just want the government to stay out of their bedrooms. And that's the message we need to stick with. So there's that on the one hand. Simultaneously, there's much less focus on Supreme Court confirmations, on explaining the relevance of Supreme Court confirmations to people who are not focused on the courts. I think that was a mistake too. But there's also an element of just, I think, people who are progressive not playing the same game. It's pretty clear by the time you get to the 1990s on the anti-abortion side that the game was to not just chip away at Roe, but to change other rules in the democracy to facilitate the elimination of abortion rights. There's a quite clear moment where you see people saying on the anti-abortion side, from our viewpoint, this is the Holocaust. This is the greatest human rights violation of our time. And if that means we are not going to fight fair, so be it. If that means, the country has to become less democratic, or that's so be it. I mean, that's worth it to us. So there's clearly a lot of asymmetric polarization going on. I think you see the anti-abortion movement focusing on, deregulating campaign spending, on kind of hollowing out the traditional leadership of the Republican Party to facilitate the rise of populism. Like, there's a lot of things that are happening that I'm not sure we would want progressives to do, right? But that the polarization is asymmetric enough. And sometimes I think was either not recently, but early enough, either downplayed or minimized by progressives. I for many years, when people would ask me as a historian what happened, the question was always exclusively, what did progressives do wrong? As if it was sort of, Laurel and Hardy on the right, and then, a bunch of brilliant geniuses like Albert Einstein on the left, and Albert Einstein just had to have dropped the ball. Clearly, there couldn't have been anything going on the other side. And I think that attitude was probably part of the problem too, because there's been some fairly sophisticated planning that was being downplayed, right? I think because of the awareness that people who were progressive had, that they had a popular majority, right? They had good constitutional arguments. And there was, I think, reasoning that surely if that was true, it would not be that hard to preserve what many in the United States viewed as a fundamental right. Of course, again, the game was different. The game was not about popular opinion. It wasn't about what majorities wanted. It wasn't about precedent. It wasn't about good constitutional arguments. And so I think at times progressives lost sight of that, or when they realized it, it was too late. And we had the court we have now, which is a court that I think, as Melissa was saying, is, and Michele too, is not going to limit the kinds of revolutionary changes it's making to abortion, right? I mean, this is, and it's worth emphasizing, as much as Roe is controversial, if they're willing to do this with Roe, they're willing to do this with anything, because most people know what Roe is, right? If you ask the average American, do you know of any Supreme Court decisions? The answer will probably be no, but if the answer is yes, the decision they will name is Roe v. Wade. And so if they're willing to do this, this is when you would expect the backlash to be the most acute, because of precondition of backlash is knowing what is actually happening. So if they're doing this in the light of day to this decision, the best known Supreme Court decision that recognizes a fundamental right, ask yourself what they're going to do when it's a right you don't know about or a case you haven't heard of, right? And the answer, I think, is pretty clear.
Yeah, I mean, I think you covered so much ground there, and I want to pull out one thread of it, which is the notion that if the progressive or the pro-abortion rights side could just make a really good argument, or if Roe had been argued differently, then maybe this would be different. But in some ways, if you read that majority opinion, and particularly as several of you have flagged, how unresponsive it is to both the dissent and the public debate, they don't care what the argument is, right? I mean, Melissa, you co-wrote a brilliant amicus brief about equal protection. They did a little half-hearted paragraph just saying, nah, the best arguments in the world cannot unstick a very determined ideological movement that saw its opportunity. I think it is one of the lessons that we're seeing here. Did you want to jump in, Melissa?
No, thank you for highlighting the brief that Reva Siegel and Sarita Mayuri and I submitted to the court, which highlighted the equality arguments that could be used to invalidate the Mississippi 15-week ban, and highlighting the history and noting that Roe was decided at roughly the same time that the Supreme Court was beginning to develop its jurisprudence that actually read women into the Constitution. So just like there is no right to an abortion explicitly enumerated in the Constitution does not explicitly speak of women. That came through the process of judicial review and interpretation that began in 1971, continued in 1973 in a case that was decided the same term as Roe, and then continued even further, culminating in 1996 when Justice Ginsburg wrote her opinion in United States versus Virginia, the case that invalidated the Virginia Military Institute's policy of refusing admission to women. And I think if you follow the logic of those sex-based discrimination cases, it is very difficult to uphold the Mississippi ban on the ground that somehow it is not an impermissible and unconstitutional form of sex-based discrimination against women. And the court does not even grapple with this. It simply says that its precedence forecloses the prospect of recognizing an equal protection right to choose an abortion, leaving aside the fact that the court has not really heeded the limits of precedent at any other point in this opinion. So,
I mean, to me, it raises a lot of scary concerns about the other cases that you just mentioned that read women into the Constitution and read sex equality in general. Because I read your brief and I found it very persuasive, and you make a very strong historical and analytical case. And yet, if the idea is that they cannot fathom connecting abortion with sex equality, what happens? And to Mary's point, what happens to those precedents that say that sex-based classifications are subject to higher scrutiny? And that is, of course, at the heart of Justice Ginsburg's legacy. I want to very quickly, we don't have a ton of time left, so I just want to step back for a second and talk about what the real world implications have been to Dobbs in just 10 days. There were women who had appointments at clinics the very day that it came by, who came down that were on their way to the clinic, that were at the clinic. There's heartbreaking reporting, women pulling over by the side of the road to cry, being told at the clinic, we cannot help you just because their appointment happened to fall on that day. Abortion funds in multiple states having to pause their operations out of fear of being prosecuted, despite Brett Kavanaugh assuring everyone that interstate travel is secure. Different clinics offering only certain procedures, such as only procedural abortions and not medication abortions for people coming from states with bans because they're worried about what happens when, for example, someone from Montana goes back to South Dakota and takes the second part of an abortion pill. So we're already seeing an interstate chilling effect. We're seeing Plan B and other forms of contraception being called into question or even being frozen. We're seeing medical treatments for individuals who are not even pregnant being withheld out of fears that they could harm a hypothetical pregnancy, treatment for lupus. We're seeing a lot of questions around ectopic pregnancy. So basically the parade of horribles, we didn't even have to wait 2 weeks. We didn't even have to wait a week to see that all kinds of medical care, chiefly, but not only abortion, is being imperiled, and not only in states that have bans on the books. At the same time, we've been seeing some of the trigger laws being enjoined in state courts. It's wild out there. It is terrifying. And I'm just wondering, I know we only have 10 minutes, but given the kind of breathtaking, I'm just going to use a cultural word, chutzpah, in transforming American law that the majority did here, how does the law move forward when it comes to protecting or seeking to protect these basic freedoms? And I know we talked about the equal protection argument. Michele, you've made a really brilliant 13th Amendment argument. But practically speaking, given the court's composition, not just what you think is a solution, but actually what you think is going to happen next. I'm going to open the floor to see who's ready to jump in. It looks like, Michele, you are.
So I'll jump in, and let me just say that it's important that we keep in mind that there are free states, and I've just been calling it free states and non-free states because so much of this is reminiscent of Jim Crow. So much of it is reminiscent of a time of antebellum chattel slavery in our country. And I don't say that lightly. We have to remember that the same continual thread, that rope still exists, even if some of the threads have frayed, right? We still are talking about disparate impacts on women of color. In Mississippi, we're still talking about Black women being disparately harmed. We're still talking about, in that state, a Black woman is 118 times more likely to die by being forced to carry a pregnancy to term than she is by being able to have an abortion. And so when you mentioned about the kind of trigger laws that would ban abortion outright or dramatically constrain those rights, they went into effect right at the time of the decision. And they're also meant to chill. You know, when we look at the history of laws that seek to do damage to the soul, the spirit, the citizenship of vulnerable people in the United States, it's not just the weight of the law itself, but it's the weight of the threat of the law itself. It's the weight of the threat of those people who believe that they have been empowered by law, third parties, in order to enforce a vision of law, which we shouldn't forget. You know, during Jim Crow, it wasn't just police officers that were wielding the weight of the law. We saw individuals coming out to also exercise tremendous violence against people who were seeking freedom and equality under law. So right now, the hopeful note is that in California, New York, Illinois, Colorado, and other states, they're willing to do the work to help people who need reproductive health care services, including abortion. But at the same time, Irin, and I'll just close with this, is that the depravity in front of us is something that we'll all be able to see. The fact that there are legislators in Mississippi who, when asked, do you support a 12-year-old who's been raped, maintaining a pregnancy against her will? And there have been lawmakers that have just stared into cameras and said, yes, this is the America we're living in now, where states will force a 10, 11, 12-year-old, 13-year-old girl to become a mother at that age, and then render no meaningful help to her afterwards. And I think that we have to be very clear about the kind of violence then that the state is doing. And let me just close with this, that, we're in a country that has done away with the draft. We have said we do not believe that men should use their bodies in service of our country, to defend the interest of our country, to protect Americans, even if we're under threat of war. And yet at the same time, we have legislatures doing this, essentially putting girls and women in a version of a kind of reproductive draft. And I just can't help but think about just the irony in that.
Thank you for that. Anybody else want to jump in on where the law goes from here?
I honestly have no idea. I mean, one thing that kind of interests / frightens me is that if you study the anti-abortion movement, it used to be that there was a hierarchy, right? I could say, if you want to know what people are probably going to do in states with anti-abortion majorities, you can Google the game plan of the organizations that send model laws to every state. That hierarchy has completely fallen apart. So if you ask me, for example, are states going to try to overtly rather than covertly punish pregnant people? I couldn't tell you the answer. And I can't point you to the person in the anti-abortion movement who could tell you the answer, because the movement has fragmented. There are different captains of the ship in every state. And so in terms of how far we're going to see legislators go, I don't think anyone in good faith can answer that question right now. And if that sounds frightening, it's because it is. Like, I've studied this for a long time. I have no idea. I don't think anybody knows. I think, frankly, people in the movement were surprised that they got the ability to do this quickly. And so I think what we're seeing now is the tip of the iceberg. And I really am not sure what will happen next, because I don't think there's anyone deciding that. And I think that opens possibilities when it comes to, obviously the treatment of pregnant people, but much more than that would have been probably unimaginable a few years ago.
There is this feeling, right, that they're going for broke. These legislators that used to not even say out loud that they wanted to do these things, or might have at least blinked at the kinds of questions that Michele mentioned about child assault victims. But now this feeling of, well, if we got this, we might as well say what we really want. And to me, that also just seems very related to Trump, right? You used the phrase, Melissa, about the quiet part out loud. It seems like many state legislators, and not just the marginal ones, the ones who are in power, are saying the quiet part loud. And that means, as you say, married, everything is up for grabs. And these groups that were counseling the 15-week ban was supposed to be an incremental ban, and they went for all of it. So that's another illustration of how the old rules no longer apply. Melissa, I want to make sure you have time.
I think it's going to be very difficult to sort of discern what the movement priorities are for the conservative legal movement once they've sort of speared this great white whale. And there may be more than one great white whale here. I would also put guns in that category as well. But I think what we will see is that there is going to be a raft of litigation, much of it interjurisdictional in nature, thinking about the various conflicts that emerge when you have states that are amenable to reproductive care interacting with states that are inhospitable. And so, I don't want to put too fine a point on it, but I don't think we've seen this kind of sectional conflict in the United States since segregation, or to be even more pointed, the period just preceding the Civil War. So I think this is unprecedented. And to that point, the court's utter disdain for stare decisis and precedent really is meaningful here, because we are being told that what will restrain them is the prospect of precedent. Justice Kavanaugh essentially says as much, like, the prospect of states limiting the ability of individuals to travel to other states is impossible because of the right to travel. The right to travel is an unenumerated implied right, and the only thing securing it is this court's precedents, which it's been very clear that they don't need to follow if they believe that those precedents are egregiously wrong. So we're in this sort of uncharted moment where we have a court that is completely unrestrained, has a 6-3 conservative supermajority, and the only thing, to coin a phrase from Justice Scalia, that will restrain them is their sense of what they can get away with.
Wow. Well, I want to thank these panelists. This is a very bleak moment for people who support reproductive autonomy, but you've shed so much light on how we got here, what is happening, where we're going to move forward. for better or for worse. And thank you so much for your wisdom, your brilliance, your eloquence. And I thank you so much to everyone who tuned in and to the New York Historical Society.
And I want to thank you all, Michele Goodwin, Melissa Murray, Mary Ziegler, and Irin Carmon for being with us today to discuss this historic decision. Such an informative and important conversation. And to our audience, please sign up for our mailing list and follow us at nyhistory.org to get the latest on upcoming salons like this one. Finally, the New York Historical Society on Central Park West in New York City is currently open on Wednesday through Sunday. You can reserve your timed entry museum tickets on our website. We hope to see you there to view Title IX, Activism on and Off the Field, now open in our Joyce B. Cowan Women's History Gallery. Thank you all again.